Hello, everyone, and welcome back to Beyond the Evidence, the podcast where we dive deep into true crime cases, uncovering the facts and exploring the unanswered questions that keep us coming back for more. I'm your host, Marv, and I want to thank you for joining me today. If you haven't already, please subscribe to my YouTube channel and hit the notification bell so you never miss an update. And if you'd like to support the channel, you can find links to my PayPal and Cash App in the description. Now, let's get into today's topic.
Breaking all the patterns, facts and theories, clues and controversy. Join the journey, uncovering the mystery. This is Beyond the Evidence, where justice prevails, with Marv leading the way. Truth never fails. Now get ready for this live stream. Super chat, highlight your message. Don't fall victim to the irrelevance. Hit that like, share, subscribe to Marv's Beyond the Evidence.
Hello, everyone. Welcome back. Second live for today. All right, we are done with the hearing that was the day before the trial started. And if you didn't know, transcripts are out. And that is what I am reading and will be reading probably for the next few weeks. So welcome in, Denise. Who else do we got here? Big Fish, Small Pond, Mustang, and Melissa, how you doing? Those that are watching and not chatting. Okay, so we are starting with day one of the trial. And what we're going to read is some housekeeping things that happened first thing in the morning. Then we're going to go right into jury instructions. I want you guys to pay close attention to the jury instructions, because this is what the jury has to follow when determining a verdict. Then we're going to go into opening statements. And then after opening statements are done, we'll be done for the night. Tomorrow, I'm going to try to go through as many testimonies as I possibly can. What is today? Today is Sunday? Saturday. Okay, so yes, tomorrow and Monday, I'm going to go through as many testimonies as I can in order that they were in the trial. Tuesday and Wednesday, I will be gone. We are going to visit colleges for my son, so I will be out of town. And then Thursday, when I get back, we'll start in again. And we'll keep going until we get through all of it. All right. So once again, welcome in. We are going to start with on record October 18th, 2024 at 9:10 a.m. The court. All right. We are on the record. Ladies and gentlemen, good morning. Nice to see everyone here this morning. A couple of housekeeping matters. Thank you to the state and the defense for providing their first joint stipulation regarding evidentiary matters. I think that's going to be nice and streamlining then for the jury, so that we don't have to put in a bunch of witnesses that are just for evidentiary foundation purposes. So I will sign this, accepting the stipulation, and make that part of the record. When we have bench conferences, because we have 6 attorneys, it's going to be difficult to have bench conferences. I think I mentioned yesterday to counsel that there's a table been set up over here with a microphone, and if you need to approach the bench, we can conduct our bench conferences over there. The technical assistance gentleman for Carroll County has provided the court with the instructions on how to start and stop the sidebar. Yeah, so it'll shoot white noise out through there so that it is on the record, but it's not being displayed out to the audience. I provided to counsel now the preliminary instructions and have incorporated the specific instructions requested by the defense on reasonable doubt. So we will start with the preliminary instructions. Counsel will make their opening statements, and then the state will begin to present its case in chief. And the jurors are here. They are in the jury room. And before we get started, I just wanted to advise counsel. I believe you, a couple of you, were in the outer office there when one of the sheriff's deputies indicates that members of the media had violated the court's decorum order. Apparently, a gentleman from NBC, another by the name of Eric Arnold, a gentleman by the name of Ryan Delaney, who I don't know if he's affiliated with the media or if he's a private citizen, a gentleman by the name of Alex Martin, and a Mike Conroy with the Associated Press were downstairs filming the jurors as they were coming into the building, coming into the area where they're going to be let off. Several of the members of the Carroll County Sheriff's Department observed this conduct and confiscated NBC's camera. Confiscated. And it's a video camera. One of those handheld on-your-shoulder cameras. Also confiscated Mr. Delaney's Nikon camera. Mr. Martin's camera and the Associated Press had 2 cameras. So I have confiscated 5 still cameras and 1 video recording camera. Randy the tech guy has removed the batteries and SIM cards, and the court will retain the battery, the SIM cards, and the equipment. And I will be excluding Eric Arnold from NBC, Ryan Delaney, Alex Martin, and Mike Conroy from the Associated Press from further proceedings in this matter. It's a direct violation of the decorum order. As you know, I invited counsel and the media to meet with the court yesterday. There were several members from the media here yesterday. I think there was at least 2 rows or 3 rows of media that came in. Each member that was present that had not received the courthouse management and decorum order dated September 30th, I think, I'm not sure, October 16th, excuse me, was provided with a copy of the court's decorum order. They all understood and indicated that they understood. And I know that counsel did not attend that meeting with the media because you had other things that you needed to attend to. But I wanted you to be invited if you wish to. The court order clearly states, during the trial, the media is directed that no photograph or record of the jurors is allowed, including the juror entrance exit from the courthouse. If the jurors are sequestered, this prohibition shall also include travel, dining, and lodging locations for the jury, as well as parking and transportation vehicles when the jurors are present. Any violation shall result in the item being confiscated and erased. And violators and their affiliated organizations are subject to being excluded from the courtroom for the remainder of the trial. Direct violation. I thought I was perfectly clear with the media, both in written form and in the meeting that we had yesterday. But clearly, there are media that feel that they do not have to honor this court's order. So they will be excluded, and their equipment has been confiscated and will not be returned. And they will not be permitted in the building for the remainder of the trial. Any issues with the court's statement, Mr. McClelland? Mr. McClelland, no, Your Honor, not from the state's perspective. The court, Mr. Rozzi? Mr. Rozzi, no, ma'am. The court, okay, I think it's important that Mr. Allen gets a fair trial and that he gets a trial free from the nonsense of the media that continues this morning, which is why we're late getting started. And I apologize that we're late getting started, but I felt it was very important that I address it with the officers, with the sheriff's department, and they will be making a report, and I'll provide that report to council when I receive it. So with all that being said, is there anything we need to do outside the presence of the jury before they are brought in for prelims and openings? Mr. McClelland. Mr. McClelland, no, Judge. The state had an opportunity to review the preliminary instructions. The state is satisfied with what the court has provided. The court. All right. Thank you, Mr. Rozzi. Mr. Rozzi, same for the defense. The court. And I will just remind counsel that opening statements is not argument. It's a preview of what you expect the evidence will be. I did last night have an opportunity to review, and Jody has provided you copies of the, and I apologize, these are handwritten orders. I were busy at night, just like you guys are busy at night, and we had some printing issues. So having taken the composite sketch motion in limine under advisement, I've granted that. I'm prohibiting the defendant from using the composite sketches in the trial. I previously granted the motion for separation of witnesses and then authorized the state to have its two. The motion in limine, and I ruled on those on the bench, so this isn't news to you, except for the composite sketches, which I took under advisement. So the rest of the motions that we discussed and I ruled on the record have been memorialized in a handwritten order. And again, I apologize that they're handwritten, but I can't do anything different than that. So that's what we've got. Okay? Mr. Rozzi, may I? The court. Yes, sir. Mr. Rozzi, on that issue, there's still the remaining issue of Mr. Tobin's. The court. Yes, yes. Mr. Rozzi, I'm just making sure that I didn't get that document. The court. No. That has not fallen off the radar. But you provided me with, I think it was Dr. Warren's deposition and several CVs that I need to review and read. And I apologize that I did not get to that late last night. By 2:00 this morning, I figured it was more important that I rest rather than finish that process. So I'll have that for you tomorrow. Mr. Rozzi, very good. Thank you. The court. I hope that doesn't interfere with opening statements. I assume that it wouldn't, but okay. And Mr. Baldwin is shaking his head no. You are doing opening for the defense? Mr. Baldwin, I am, Judge. The court. And who is for the state? Mr. McClelland. Judge, I am. The court. Mr. McClelland? Yes, Judge. The court. Okay, let's bring our jury in, gentlemen. And just a reminder, folks, if you leave the room while we're we are working, while business is being conducted, the door is being monitored by security, and they will not let you back into the room until such a time as we have a break in a witness. Please don't talk out in the audience. It's distracting. You may think you're being quiet, but when there's 30 of you being quiet, it's kind of noisy. So it's important that the attorneys not get distracted by your noise. I do have to say that we were yelled at several times, more than several times throughout this, because we were noisy. Let me just tell this individual that I'm live. Okay. Let's see. Mr. McClellan, Judge, in that effort, we do have a few witnesses the parties have agreed that can stay in during opening statements. The court, yes. Mr. McClellan, and then they will exit after opening statements. The court, that's fine. Mr. McClellan, because they're part of the separation of witnesses. The court, thank you. Mr. McClellan, so you will see a few people exit after opening statements, Judge. The court, thank you. And obviously, the prohibition doesn't apply to the attorneys. And I know you all have several staff members and attending folks that are helping you with various odd and sundry things. And clearly, that does not apply to your staff and your assistants. And I appreciate that the defense has indicated that they'll try to shield the laptop that one of your assistants is using to make sure it's not displaying inappropriate information. So thank you, sir. What they were talking about in that section is the fact that they allowed the family members that were testifying, Becky Patty, Kelsey German, Carrie Timmons, Anna, to stay in the courthouse, in the courtroom for opening statements. As soon as opening statements were ended, they all had to leave the courtroom and be outside until they got finished testifying. Once they were finished, then they were allowed to come back in. The bailiff, all rise. Jury in at 9:21 a.m. The bailiff, thank you. You may be seated. The court, thank you, Jeremy. Well, good morning, ladies and gentlemen. It's nice to see you this morning. I hope your travel down and your stay last night was pleasant enough, considering what it is that we are all here assembled to do. You have in your possession a folder. Inside that folder is several pads of paper and pens for your purposes in taking notes and for asking questions. At the conclusion of the day, just leave those materials there on your chairs. Jody will collect those and lock them up with her things. She doesn't look at anything. She will just lock those up and make sure that you have what you need for the balance of the trial. You may take your folders with you when you take our breaks and over the noon hour, but you will need to leave them here over our evening recess. I apologize for the little bit of delay. I'd hoped to get started right at 9 o'clock. There were a couple of housekeeping matters that I needed to attend to. These attorneys have been here waiting and ready to go, and so I apologize for the brief delay. I try to keep jurors advised of what it is that we're going to be doing. So the next step in the proceedings is the court will read its preliminary instructions. I have provided to you copies of those instructions. You may follow along as I read those if you wish. Once I'm done, the attorneys will make their opening statements. The state will present its statement first, and then the defendant will present his opening statement, after which the state will begin to present its case in chief. I provided copies of these to you, and you may follow along if you wish. This is a criminal case brought by the state of Indiana against Richard Allen. The case has commenced when information were filed charging the defendant with count 1, felony murder, a felony, count 2, felony murder, a felony, count 3, murder, a felony, and count 4, murder, a felony. Those informations, omitting formal parts, read as followed. Count 1. On February 13, 2017, in Carroll County, Indiana, Richard Allen did kill another human being, to wit, A.W., while committing or attempting to commit kidnapping. Count 2. On February 13, 2017, in Carroll County, Indiana, Richard Allen did kill another human being, to wit, L.G., while committing or attempting to commit kidnapping. Count 3. On February 13, 2017, in Carroll County, Indiana, Richard Allen did knowingly or intentionally kill another human being, to wit, A.W. Count 4. On February 13, 2017, in Carroll County, Indiana, Richard Allen did knowingly or intentionally kill another human being, to wit, L.G. The crime of murder is defined by law as follows. A person who kills another human being while committing or attempting to commit kidnapping commits felony murder, a felony. Before you may convict the defendant, the state must prove each of the following beyond a reasonable doubt. 1. The defendant, Richard M. Allen, 2. Killed, 3. A.W. 4. While committing or attempting to commit kidnapping, which is defined as a person who knowingly or intentionally removes another person by force or threat of force from one place to another. If the state fails to prove each of these elements beyond a reasonable doubt, you must find the defendant not guilty. If the state does prove each of these elements beyond a reasonable doubt, you may find the defendant guilty of count 1, felony murder, a felony. The crime of murder is defined by law as follows. A person who kills another human being while committing or attempting to commit kidnapping commits felony murder, a felony. Before you may convict the defendant, the state must prove each of the following beyond a reasonable doubt. Once the defendant, Richard Allen, 2. Killed, 3. L.G., 4. While committing or attempting to commit kidnapping, which is defined as a person who knowingly or intentionally removes another person by force or threat of force from one place to another. If the state fails to prove each of these elements beyond a reasonable doubt, you must find the defendant not guilty. If the state does prove each of these elements beyond a reasonable doubt, you may find the defendant guilty of count 2, felony murder, a felony. The crime of murder is defined by law as follows. A person who knowingly or intentionally kills another human being commits murder, a felony. Before you may convict the defendant, the state must prove each of the following beyond a reasonable doubt. 1. The defendant, Richard Allen. 2. Knowingly or intentionally. 3. Killed. 4. A.W. If the state fails to prove each of these elements beyond a reasonable doubt, you must find the defendant not guilty. If the state does prove each of these elements beyond a reasonable doubt, you may find the defendant guilty on count 3, murder, a felony. Again, the crime of murder is defined by law as follows: a person who knowingly or intentionally kills another human being commits murder, a felony. Before you may convict the defendant, the state must prove each of the following beyond a reasonable doubt. 1. The defendant, Richard Allen. 2. Knowingly or intentionally. 3. Killed. 4. LG. If the state fails to prove each of these elements beyond a reasonable doubt, you must find the defendant not guilty. If the state does prove each of these elements beyond a reasonable doubt, you may find the defendant guilty of count 4, murder, a felony. The defendant has entered pleas of not guilty, and the burden rests upon the state of Indiana to prove to each of you beyond a reasonable doubt every essential element of the crimes charged. The charges which have been filed are the formal method of bringing the defendant to trial. The fact that charges have been filed, the defendant arrested, and brought to trial is not to be considered by you as any evidence of guilt. Under the law of this state, a person charged with the crime is presumed to be innocent. To overcome the presumption of innocence, the state must prove the defendant guilty of each essential element of the crimes charged beyond a reasonable doubt. If the evidence lends itself to two reasonable interpretations, you must choose the interpretation consistent with the defendant's innocence. Let me read that again. I want to make that clear to everyone. To overcome the presumption of innocence, the state must prove the defendant guilty of each essential element of the crimes charged beyond a reasonable doubt. If the evidence lends itself to two reasonable interpretations, you must choose the interpretation consistent with the defendant's innocence. If there is only one reasonable interpretation, you must accept that interpretation and consider the evidence with all the other evidence in the case in making your decision. The defendant is not required to present any evidence to provide his innocence or to prove or explain anything. The state has the burden of proving the defendant guilty beyond a reasonable doubt. Some of you may have served as jurors in civil cases where you were told it is only necessary to prove that fact is more likely true than not true. In criminal cases, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every possible doubt. If based on your consideration of the evidence, you are firmly convinced the defendant's guilty of the crimes charged, you may find him guilty. If, on the other hand, you think there is a real possibility that he is not guilty, you should give him the benefit of the doubt and find him not guilty. The burden is upon the state to prove beyond a reasonable doubt that the defendant is guilty of the crimes charged. It is a strict and heavy burden. The evidence must overcome any reasonable doubt concerning the defendant's guilt, but it does not mean that the defendant's guilt must be proved beyond all possible doubt. A reasonable doubt is a fair, actual, and logical doubt based upon reason and common sense. A reasonable doubt may arise from either the evidence or from the lack of evidence. Reasonable doubt exists when you are not firmly convinced of the defendant's guilt after you have weighed and considered all the evidence. A defendant must not be convicted on suspicion or speculation. It is not enough for the state to show that the defendant is probably guilty. The state must prove each element of the crimes by evidence that firmly convinced each of you and leaves no reasonable doubt. The proof must be so convincing that you can rely and act upon it in this matter of the highest importance. You are the exclusive judges of the evidence, the credibility of the witnesses, and the weight to be given the testimony of each of them. In considering the testimony of any witnesses, you may take into account his or her ability and opportunity to observe the manner and conduct of the witness while testifying. Any interest, bias, or prejudice the witness may have, any relationship with other witnesses or interested parties, and the reasonableness of the testimony of the witness considered in light of all of the evidence in the case. You should attempt to fit the evidence to the presumption that the defendant is innocent and the theory that every witness is telling the truth. You should not disregard the testimony of any witness without a reason and without careful consideration. If you find conflicting testimony, you must determine which of the witnesses you will believe and which of them you will disbelieve. In weighing the testimony to determine what or whom you will believe, you should use your own knowledge, experience, and common sense gained from day-to-day living. The number of witnesses who testify to a particular fact or the quantity of evidence on a particular point need not control your determination of the truth. You should give the greatest weight to that evidence which convinces you most strongly of its truthfulness. During the progress of the trial, certain questions may be asked and certain exhibits may be offered, which the court rules are not admissible into evidence. You mustn't concern yourself for the reasons for those rulings. Since the production of evidence is strictly controlled by rules of law, you mustn't consider an exhibit or testimony which the court orders stricken from the record. In fact, such matter is to be treated as though you never heard it. Nothing that I say during trial is intended as any suggestion of what facts or verdicts you should find. Each of you as jurors must determine the facts and the verdicts. The evidence must be judged and considered from your memories of the testimony of the witnesses and such exhibits as may be admitted for your examination. You may take notes during the trial if you wish. Do not become so involved in note-taking that you fail to carefully listen to the evidence or to observe the witnesses as they testify. Transcripts of witness testimony will not be available to you during your deliberations, so please pay careful attention during the testimony. Notes are not evidence in the case and mustn't take precedence over your independent recollection of the evidence. They are only an aid to recollection and are not entitled to any greater weight than your recollection or impression as to the actual evidence. Your notes should not be disclosed to anyone other than a fellow juror during deliberations. Do not take your notes outside of the court or the jury room. The court has furnished you with paper and pens. You are allowed to submit questions to witnesses to clarify their testimony during trial under certain conditions. If you feel the answer to your question would be helpful in understanding the case, please raise your hand after the attorneys have completed their examinations, but before the witness is excused. You must write your question down and hand it to the bailiff. I will then privately confer with the attorneys about your question, and I will make a ruling on whether your question may be asked under our law. If the question is of the type that is allowed, I will address the question to the witness. Please do not directly speak to the court, the lawyers, or the witnesses, but carefully follow this procedure if you wish to have a specific question addressed to a witness. Your verdicts must represent the considered judgment of each juror. In order to return a verdict of guilty or not guilty, you must all agree. After you return your verdicts, you are under no obligation to discuss them or the reasons for them with anyone. The trial of the case will proceed as follows. First, the attorneys will have an opportunity to make opening statements. These statements are not evidence and should be considered only as a preview of what the attorneys expect the evidence will be. Following the opening statements, witnesses will be called to testify. They will be placed under oath and questioned by the attorneys. Documents and other tangible exhibits may also be received as evidence. If any exhibit is given to you to examine, you should examine it carefully, individually, and without comment. When the evidence is completed, the attorney will make final statements. These final statements are not evidence, but are given to assist you in evaluating the evidence. The attorneys are permitted to argue, to characterize the evidence, and to attempt to persuade you to a particular verdict. You may accept or reject these arguments as you see fit. Finally, just before you retire to consider your verdicts, I will give you further instructions on the law which applies to this case. During the trial, there will be periods of time during which you will be allowed to separate, such as a recess for rest and overnight, where you're outside the jury room. You mustn't discuss the case among yourselves or with anyone else. However, you may discuss the evidence with your fellow jurors during recesses from the trial when all of you are present, as long as you reserve judgment about the outcome of the case until deliberations begin. If anyone makes any attempt to talk to you concerning this case, you should report that fact to the court immediately. Until your jury service is complete, while you are outside of the courtroom or the jury room, you may not use computers, laptops, cell phones, other electronic devices, or any other method to conduct research on your own or as a group regarding the case. To gather information about the issue in this case, to investigate the case, conduct experiments, or attempt to gain any specialized knowledge about the case, to receive assistance in deciding the case from any outside source, to read, watch, or listen to anything about the case from any source, to listen to discussions among or receive information from other people about the case or talk to the parties, the lawyers, any of the witnesses, or members of the media, or anyone else about this case, including posting information, text messaging, email, internet chat rooms, blogs, and social websites. During the trial, you mustn't consume any alcohol or drugs that would affect your ability to hear the evidence fairly and impartially. You should keep an open mind and not reach a judgment about the outcome in this case until you've heard all of the evidence, the arguments of counsel, and the final instructions on the law, and you begin your deliberations. First, then, for opening statements. Mr. McClelland. All right, guys, that was the jury instructions. What do you guys think? I'm going to go back through the chat here, just see what you guys had said. Hi, Jackie. Let's see. Everybody's saying hello to each other. Hello to me. Thank you. Bossy and Gibbo are picking on each other, I see. All right. Robin says, thank you for going over this. I need to hear what was said in the courtroom as to regarding what is reasonable doubt. Yeah. I mean, those instructions were pretty clear. Hey, Miracle Hearts. She says she's listening in. Very good, clear reading of the transcript. Thank you. The Bish, formerly known as Delulu, says, hey, all, driving and listening. I do that all the time. You're good. True Crime with Frank Meister says, good evening, everyone. Fairly clear, but I guess I would have to clarify again at the closing to reconfirm my understanding. And we'll do that, Robin. Definitely. I mean, there's so much more at the instructions at the end, but this is just their initial instructions. So, are we ready for opening statements, everyone? Let's see here. All right. So she says, Mr. McClelland. Mr. McClelland, thank you, Your Honor. Judge, I apologize. Hang on. Yep. The court. That's all right. Mr. McClelland, I'm having technical difficulties ready at the start off of the trial. Not a good way to start. I understand. The court. Not a problem. We have all struggled with technology. Mr. McClelland, I appreciate that, Judge. Thank you. The court. Do you need Randy to come in here? Mr. McClelland, I think we need just a moment, Your Honor. The court. Okay. Mr. McClelland, the court may not, but the court. Okay. At this point, Nick McClelland was going to show Libby's video of Bridge Guy. However, the new TV, and I was sitting there for this, the new TV would not cooperate. So he had to go to plan B, which is do his opening statement without that video. So he says, ladies and gentlemen, good morning. We're having a little bit of technical difficulties. I was hoping to show you a video, but it's not going to work out. A few short days ago, I told you this case was about Bridge Guy, or about Bridge Guy, a bullet, and the brutal murder of two young girls. I don't accept that, Rebecca Ann, and you're just a troll, so bye bye. You are getting banned. Okay. So let's see here. A few short days ago, I told you this case was about Bridge Guy, or about Bridge Guy, a bullet, and the brutal murders of two young girls. Now it's time for you to hear the rest of the story. How Richard Allen murdered AW and LG. I want to take you back the February 13th of 2017, a day where everything changed for AW and LG. As we told you before, it was an unseasonably warm that day in Carroll County. It was a nice summer day in the middle of winter. Hint of spring, which was just around the corner. On top of that, AW and LG had a day off of school. So they decided to go out to the trails, specifically out to the Monon High Bridge, to be outside, enjoy nature, enjoy the weather, enjoy their day off of school. Now, I told you before the trails are a trail system in Delphi. There are trails that wind through the city. They go through various wooded areas and go along and across streams, rivers, and creeks. The Monon High Bridge is an abandoned train trestle. It's 60 feet above the Deer Creek. So the girls headed out to the trails. They asked Kelsey German to go with them. She wasn't able to. However, she was able to give them a ride. On the way to the trails, LG snapped pictures of her and AW in the back seat of Kelsey's car, laughing, joking. Kelsey dropped the two girls off at the entrance of the trails, what is known as the Mears entrance. The entrance goes along the property of the Mears family, owned by the Mears family, so everyone in this community refers to it as the Mears entrance. They entered into the trails through this entrance, and they headed toward the Monon High Bridge. I want to tell you a little bit about AW and LG. First of all, from hearing me in court and hearing me speak, you know they commonly go by AW and LG. What they're commonly referred to, they were best friends. They were always together. They were really more like sisters than friends. To put it into perspective, out of the two of them, only LG had a phone, but LG had AW's fingerprint put in her phone so that AW could use it anytime she wanted. They both were also students at Delphi Middle School, so they hung out together. They went to school together. They did everything together. They were best friends. As they went down the trail, LG was on her phone, like most teenagers. She was talking to friends, texting family. She was on Snapchat. She was able to look at pictures from other friends, posting her own pictures. And I know everyone knows what Snapchat is, but it's an app you have on your phone where you take a picture and you can post it online. The picture's up for a period of time and then it disappears. It's a pretty popular app for the kids in this community. She did that as AW and her walked down the trail towards the Monon High Bridge. I want to tell you a little bit about the bridge. Now, I'd hope the video was going to show the bridge. And maybe I'll be able to show you a video of it later. But it's a very high bridge. It's a very old bridge. And it's a very long bridge. Once you're on the bridge, there's nowhere to go. There's no rails. There's only a few platforms in certain places. If you had to escape and you were on the bridge, you'd have nowhere to go but to jump off. The railroad ties that hold together the bridge are falling apart. Some are broken, some are loose. Heck, even some of them are missing altogether. It's scary to cross and it's flat out dangerous. But again, as I told you a few days ago, middle school and high school kids in our community love to cross the bridge, mostly just to say they did it. I even did it when I was in high school. And they crossed the bridge. LG continues to use her phone, continues to take pictures and post them on Snapchat. Takes a picture of AW, posts it on Snapchat. As they crossed the bridge, LG went first and AW followed. As LG got to the end of the bridge, she waited for AW. LG continues to play on her phone, but as she got to the end, she looked back and she noticed a man was following AW. And something inside LG told her that she needed to get her phone out and film the man following AW. 2:13 p.m. is when she did that. The man follows AW off the bridge to where LG is standing. He then pulls out a gun and orders both of the girls down the hill. Those chilling words, girls down the hill. They complied against their will, and as this happens, the video on AW's phone cuts off, or LG's phone cuts off. Imagine 13 and 14 years old, you're with your best friend, the weather's beautiful, you're off of school, you decide to have some fun, go to the trails, and cross the bridge, a local challenge in our community. While you're doing that, you're laughing, you're joking, you're posting pictures on Snapchat, but as you end the bridge, you notice a man following you. You get that chill, that feeling that you have when something isn't right. You pull out your phone and you took the video, the man, and as you do, your friend runs to your aid. The man approaches, pulls the gun, and orders you and your friend down the hill. Imagine the fear you would have, a gun pointed at you, being ordered down the hill against your will. Out of fear, the girls complied. They complied with his orders, not knowing what he wanted or what he was going to do to them. Completely powerless. He had the power and the fear and forced them down the hill. Later that day, Derek German arrives at the trail to pick up the girls, but the girls are nowhere to be found. He calls other family members to assist, but no one can locate the girls. The police are called and a search is started. The search ensues for the girls until 2 a.m. on February 14th, and then it picks up again later in the morning at 6 a.m. As the search progressed through the day, the girls were ultimately found. Both were dead, 13 and 14 years old. They were found just upstream from the Monon High Bridge near the Deer Creek. You're going to see pictures of the scene. It was a gruesome scene. LG was completely naked, covered in blood, with her throat cut in several places. LG's blood was all over the ground in several places, and even on one of the trees. AW, she had on her own undershirt, but she had on LG's sweatshirt and LG's jeans. AW had her own shoes on, but no socks. Her throat was also cut. The rest of the girl's clothes were found in the Deer Creek, with the exception of two things: one of LG's shoes and LG's cell phone. They were found underneath the body of AW. Also found at the scene was a lone bullet, an unspent bullet, inches away from the bodies of AW and LG. Specifically, a Winchester .40 caliber bullet. The phone, along with the other items, were sent to be processed to see what evidence could be gathered, to see what they could find. On the phone were the last pictures taken by LG of her and AW. Those pictures that LG took while on the ride in Kelsey's car. All right, what's going on? Whatever, Jared. All right, took care of that. Sorry about that. Okay. There's also the video LG took. The video at the end of the Monon High Bridge that showed the man that was following AW. That showed the man who kidnapped AW and LG. The man we know as Bridge Guy. As the investigation progressed, witnesses started to come forward with information. You're going to hear from three girls that were on the trail that day: Anna Spath, Riley Voorhees, and Brianna Wilbur. And they were on the trail as well, taking pictures of nature with friends, laughing, joking. They stopped and took a picture at a bench just east of the Freedom Bridge, and right after that, they ran into a man along the trail and later described that male as walking with a purpose, but not very friendly. Most importantly, they're all going to testify that the man they saw on the trail that day is Bridge Guy. Let me repeat that. Most importantly, they're all going to testify that the man they saw on the trail that day is Bridge Guy. You're then going to hear from Betsy Blair. She came forward. She was on the trail that day as well. She uses the trail to exercise. She walks the loop on the trail for her exercise daily. She walked down to the Monon High Bridge, and when she got to the Monon High Bridge, she saw the male out on the first platform on the bridge. She'll testify the guy she saw is Bridge Guy from LG's video. You're then going to hear from Sarah Carbaugh, who said that she drove east on 300 North that day. She saw a man walking along the side of the road, and that man was muddy and bloody, like he had just slaughtered a pig. And she'll tell you the man that she saw was bridge guy. Years passed, and through the years, investigators worked on the case, tried to find additional clues. Included in the people working on the case was a gal named Kathy Shank. As she was reviewing old reports, she came across a report by a DNR officer, Department of Natural Resources, named Dan Doolin. And in 2017, he spoke to Richard Allen and he made a report. And then he spoke to Richard Allen in 2017. Richard Allen told them that he arrived at the trails at 1:30 and he was there until 3:30. And that while he was on the trail, he ran into 3 girls. Kathy immediately took this report to Tony Liggett, who was the detective at the time. You're going to hear Tony Liggett testify that the tip stuck out to him immediately because he knew that if he could find the man that ran into 3 girls, they would be able to identify Bridge Guy. And so it immediately stuck out to him. Law enforcement immediately called Richard Allen. They interviewed him. Richard Allen admitted he was on the trail on February 13th, 2017, that he ran into 3 girls on the trail. He also stated he was wearing a blue or black Carhartt coat, jeans, and fit the description of the man on the bridge. Also found out that he owned firearms. Investigators searched Richard Allen's house and they found a blue Carhartt jacket, several knives and box cutters, boots, and a .40 caliber gun with a .40 caliber ammunition. The gun was sent to the lab and tested, and it was confirmed that the bullet at the scene was cycled through Richard Allen's gun, and it came from Richard Allen's gun. The bullet that was found between the 2 bodies of AW and LG. Richard Allen was brought in for a second interview. This information was put in front of him. He had no explanation for how his bullet ended up between the bodies. I don't know. The story could have ended there. Richard Allen was arrested, and while he was incarcerated, he confirmed what investigators knew, that he was the one that killed AW and LG. And it just wasn't one admission. It was several. Some with details of the crime, how he did it, why he did it. And these aren't admissions he made while he was being interrogated or being tortured or even being asked questions by the police. These are admissions that he told his wife, his mother, unprovoked admissions that were freely and knowingly made, admissions that had details that only the killer would know. You're going to hear those details. For 5 years, he lived in this community. He worked in this community. He hid in plain sight. The state is confident. After you hear this evidence, you will be firmly convinced that Richard Allen is the man on the bridge that kidnapped AW and LG and then intentionally murdered them, that Richard Allen is the man on the bridge, and that he used his gun to gain power over the 2 girls and force them down the hill. The words that he uttered to those girls, that he forced them down the hill and he was going to have his way with them. But he was interrupted. And we're going to talk to you and tell you about that interruption. And after which, he forced them to cross the creek and he killed them. The evidence will show the last face the girls saw before their throats were slit was Richard Allen's face. The state believes that you'll be firmly convinced that he is the one that killed AWNLG. Thank you, Judge. Okay, I need like 3 minutes to go to the bathroom. Maybe 3 to 4 minutes. I need to go to the bathroom. I need to let the dog out. She's pacing back and forth. I can hear her. And then we will come back and read the defense's opening statement. So talk amongst yourselves, go grab a drink, popcorn, whatever you need, and then we'll come back in about 4 or 5 minutes and read the defense's opening statement. I'll be back shortly. Okay, I am back. In the beginning, I said that I wanted to put this information out for those that couldn't read it. Well, as you can see, now that we're getting into the meat and bones of everything, we have individuals coming and putting nasty comments in the chat. This is another reason why I'm taking the time to read this. There are people out there that say that I'm a liar, this didn't happen in court, that didn't happen in court, and I'm proving them false by reading it. It's ridiculous. It really is. People need to grow up and mature up. Miracle Heart says, State did a good job recovering from the video fail, seeing as that was their opening impact statement. Yeah, exactly. Very good opening statement, and then they seem to cover it all in the witnesses and evidence. Yeah, you'll see there. You'll see it in the witness statement and the evidence that they did cover everything. Miracle Heart says, agree, Robin. They can't handle the truth. Yep. It's a shame. It really is. But that is why I'm going to take the time to read through everything. All right. Let's get on with Mr. Baldwin's opening statement. Mr. Baldwin, Richard Allen is truly innocent. Truly innocent. And when a man is truly innocent, there will be reasonable doubt from the evidence and from the lack of evidence. It may be hard to believe what you hear, but we ask you to wait, because in this case, you're going to find out that the evidence and the lack of evidence shows that Richard Allen is actually innocent, and that therefore there is reasonable doubt. We want the truth to come out in this courtroom for the families and for all of you, most importantly. So I'm going to preview the evidence you're going to be looking at over the next few weeks. It starts out, you're going to find out that this case and this investigation was messed up from the beginning to the middle and as recently as the last couple of days. The beginning, you'll find out that evidence was lost. Evidence is gone. Poof. Steve Mullen was in charge of that evidence. We're talking about the important evidence that happens right after they start an investigation. We're talking about evidence of interviews of key witnesses that are gone forever. And Richard Allen and his defense team will never ever get to see that evidence, and neither will you. We're talking about evidence that they don't even know who they interviewed, because they didn't even bother to write down the names of the people that were interviewed. We're talking about days and days and days of evidence right after the murders. And that wasn't all. Then a month later, they lost more evidence. From April the 29th to June the 2nd, they lost interview after interview that we will never see. Richard Allen will never have the benefit of looking at, and neither will you. You'll find out that the defense didn't even learn about that stuff until very late. We had been asking for it. That's the beginning. In the middle, you're going to find out that the state of Indiana kicked out the FBI. They were having some turf wars. You'll hear about that. Kick them out. That's going to be a problem. You're going to find out, because they not only kicked out the FBI, but their digital forensic people. you're going to find out that their digital forensic people had been given LG's phone, the extractions from that, and before the FBI had a chance to talk with the state police about their findings, if they had any, they were kicked out, and that is going to be a major problem. You'll find out here in a moment. And then, most recently, 2 days ago, you're going to find out that the law enforcement is scrambling a bit. Some of you on the one panel, I didn't talk about it, but on the other one I did. There's a hair found in AW's hand. A strand of hair was around her fingers with a root and DNA that can be extracted from that root. And DNA was extracted from that root. And the DNA analysis, her name is Bozanovsky, Stacy Bozanovsky. She will be testifying that hair, it might be from a relative of LG. We know that it's not LG's hair. The DNA from, it's not LG's hair because the DNA is not from LG. We know that it's not AW's DNA. It's a female hair. And all we need to know whether it's a family member or not, you will find all that we need. Stacy will tell you is to test the mom or the grandma or the sister of LG. And once we do that, we will know whether it's a family member or somebody else. And it could be either. And after I give my mini opening, they scrambled because in 7 years, they never turned over the sister or the mother's DNA over to the lab to find out whose hair that might be. That's even now. I hope that they get the result back of the DNA so the truth can come out in this courtroom. Truth, believe it or not, can come out in a phone. These phones, they don't lie. The data, the forensic data on these phones don't lie. It doesn't cheat. It doesn't have emotion. You're going to hear all of this. The data is hard, and the data is the data is the data. And when you find out what is on this, LG's phone is what I'm talking about. The phone that was found under AW, their case is going to start to fall apart right in front of your very eyes. The man, there's a couple of guys from the state police who are nice fellows. Their names are Brian Bunner and Chris Cecil. You're going to like them, I think. They are in charge of analyzing the phone dumps. You'll get the phone dumps and extractions, things like that. They're in charge and have been in charge of understanding the data, the hard data that doesn't lie off of LG's phone. And what you're going to find out is, sadly, they were ill-equipped to understand the data. We'll talk about that in a moment. Chris Cecil will tell you that the data from the phone dump is accurate and reliable. And we're happy about that because this data will be incredibly important in your deliberations and as you follow the case evidence. Well, I think it's important that I tell you what the state's theory is. They kind of previewed it. What I want you to do is, I'm going to ask that they be held to their theory because I think they're going to have to change that theory or their theory after this case starts evolving in front of you, okay? Their theory is that Richard Allen, we'll strike that. We'll start with LG and AW. LG and AW. AW and LG were on the ground in the woods at 4 o'clock, at the very latest, 4 o'clock. They were deceased and on the ground at 4 o'clock on the 13th. That's a Monday. It's a Monday, the 13th. And at 5 o'clock, their bodies didn't move. 6 p.m., 7 p.m., 8 p.m., midnight, 1 a.m., 4 a.m., 6 a.m. Bodies are still there according to, this is their theory. Their theory. 6 a.m., noon, these bodies didn't move. They were there from the 13th, at least 4 o'clock, they will say. Probably they're going to say more like 3:30 p.m., all the way up until the time when the bodies were recovered. That's their theory. The phone, LG's phone, they're going to say was under that body, was under AW's body at 3:30 p.m., 4 p.m. on Monday, the 13th, 5 p.m., 6 p.m., 8 p.m., midnight, 2 in the morning, 4 in the morning, 6 in the morning, all the way up until the bodies were recovered around noon on the 14th, Tuesday the 14th. That's what their theory is. That phone never moves. That's their theory. Hard data. Richard Allen. What's their theory about Richard Allen? Their theory about Richard Allen is that he arrived at the trails and parked at the CPS lot. You're going to hear a lot about the CPS lot. I got to try to recreate what you're going to find out. So as you're heading down 300 North, that's the road that takes you to the CPS lot, which is one place where cars park when they want to get on the trail. And Mears lot, that you just heard about, is a little bit farther down. So as you're driving down 300 North, this is the CPS lot. You can park there. Then you can cut over to the Monon High, the Monon Trail. It's about 100 yards or something. And so you're a little bit back further on the trail. Or you can continue to drive and head into the Mears entrance here. And now you're about halfway down the trail, if you're following. And the trail kind of runs parallel to the 300 North. And then you go down to about 50 yards and you'll be at the trail. And what the state's theory is that Richard Allen drove this way, which is not a normal way that he would ever drive. And you will learn about that. It won't even make sense that he drove this way. But that's what they need that to be the case, because you'll find out why. But he drove this way and then parked past the Mears entrance and parked the CPS entrance at 1:30. That is their theory. And at 1:30, 2 o'clock, 2:30, 3 o'clock, now, think about what's going on at this time in their theory. AW and LG are being abducted and murdered. 3 o'clock, 3:30, Richard Allen's car, they say, is parked right here at the CPS lot. 3:45, 4 o'clock. Their theory is that Richard Allen's car is parked. And then sometime around 4, after 4, Richard Allen leaves. That's their theory. You'll also find out that their theory is that once Richard Allen, and this is important, once Richard Allen left, he didn't take their phone. He didn't take LG's phone. Hard data on it. And he never came back to the crime scene. And they're going to say that that's all going to be important. So that's what they say, Richard Allen. It's what happened with Richard Allen, with the phone, and with AW and LG. What is the defense theory based upon the evidence? Well, let me go through the evidence and tell you what the defense theory is based upon that evidence. Richard Allen was never on the trail at the same time with those girls. All this identification business, these girls, and all the list of who that is, you're going to see even Riley Voorhees and those people. They're talking about some guy that's 5'11", doesn't really meet the description of 5 foot 5 inch Richard Allen. You'll make your own decisions. What? On the value of their testimony. Richard Allen was gone by 1:30, had been on the bridge walking on the trail toward the bridge at, 12:31. He's gone by 1:30. Now we know for a fact, and you will learn this from the evidence, that his car is gone by 2:15 p.m. Okay? Remember, think about the video is at 2:13. His car is gone out of the CPS lot, and if his car is gone, Richard is gone. How do we know that? What is the evidence going to be about that? Betsy Blair, you've heard her name a second ago. She is going to be an incredibly important witness for you all. Betsy Blair. You're going to like her. Betsy Blair is going to testify that when she drove by the CPS lot at 2:15, and we know that she drove by the CPS lot right around that time because there's a camera that shows her between the Mears lot. I'm sorry, this is the CPS lot and the Mears lot. Right in between, there's a camera off the Hoosier Harvest Store. That's going to be another important thing that you guys are going to be hearing about. The Hoosier Harvest Store will help give us some tent poles of times when things happen. And so we know from Betsy Blair, you're going to find this out. When Betsy Blair traveled past that camera, that 30 seconds or so later, she's going to be at the CPS lot. And when she testifies, you will hear her tell you what vehicle she saw at the CPS lot at 2:15. Again, remember what their theory is of happening at 2:15. Richard Allen has abducted the girls already, so his car should be here. Well, was his car there? Here's what Betsy Blair will testify to. My dad used to, when I was a kid, had a Comet. She thought it was a Ford Comet, but it was a Mercury Comet in the 60s. It's one of those old-timey cars, You see them out on the road sometimes, and you're like, whoa, look at that car. And it's very angular. It's got real crisp angles and lines. And she looked at it, and she had a blast from the past. Wow, that looks just like that's how she remembered it. Richard Allen's car that they say he was driving was a 2014 Ford Focus. Looks nothing like a Comet, you will see. That's the vehicle that Richard Allen was not driving, but somebody else apparently was. Richard Allen was gone by the time. That's why Betsy Blair did not see Richard Allen's car. She saw her Mercury, something that looked like a Mercury, and she will testify to that. And you will hear Steve Mullen when he's asked about that. If he's consistent, he will say, I don't know how to account for that. There's reasonable doubt on this case. Well, what does the evidence show about what happened to the girls? What evidence is there that we can have to understand what happened with the girls? What you will be seeing in this case, well, I think you're going to hear from even today from Becky Patty, who's the grandma, and that she and Derek German, the dad, they all lived together. You're going to find out kind of what they were doing early in the day on Saturday. I'm sorry, on Monday, the 14th. Okay. They might even tell you what they were doing on Saturday and Sunday, but they're definitely going to tell you what they were doing on Monday, the 13th. They had breakfast. They talked a little bit. And then at some point in time, Kelsey German, who's now Kelsey Siebert, will drive AW and LG to the trail. And I think she's going to testify today. And we know because of the Hoosier Harvest camera that Kelsey dropped them off at the Mears lot here, then drove past the camera, and that's about at 1:49 p.m., roughly. So the girls were dropped off at about 1:47, which is going to be about a few minutes before or after Betsy Blair got there. You'll find that out. Betsy Blair and the girls, they were following the girls, were basically came in right after Betsy. And then Kelsey drove this way. She's on camera, and we know that what time the girls got there. Then you'll find out the girls walk down to the trail to the bridge, and the trail is straight. And then when you get, it's like, it's like trails like maybe in your own community. You'll notice that there's asphalt and it's maybe, I don't know, this wide. And people are walking up and down and exercising and whatnot. And you go down the trail and then you get to a point and there's the bridge. This bridge that Mr. McClellan was talking, big, scary bridge. And it is. You'll see photos of it. And when you get to the bridge, you can make a choice. Back then, it was easier than it is now. That you could get on that bridge and walk forward and just go straight to the other end. And those girls got on the bridge probably around 2:05. That is what the evidence will show. And Mr. McClellan is correct. When they got on that bridge at 2:07, and by the way, they passed Betsy Blair, you're also going to find that. Betsy Blair will say as she was traveling this way, the girls were traveling this way, and they passed one another. And the girls got on the bridge and then went down here. Now the bridge is long and it's high. Now I'm on the bridge now, and this is what you're going to see. The bridge is incredibly, it's very long, and it's dangerous. As Mr. McClellan said, there's holes in it. It is kind of a thing that teenagers would do probably, and the girls walking on it. When they were about close to halfway across the bridge, 1/3 of the way, 1/2 of the way, you will see that LG was ahead over here, and she turned around and she took a photo of AW heading this way, heading to the south end of the bridge where the abduction happened. And you'll see AW there, and that happened at 2:07. So we kind of have an idea of where the girls were at 2:07. 2:13 is when the abduction happens. So we know that at 2:13, they're at the end of the bridge. So what happens then? Well, that's caught on video. And this video you will watch. And what you're going to see on that video is it's not very panoramic. You're not going to be able to see what everything is and where everything is and who is there. And you do hear this voice, girls down the hill. Now I want to stop right there because I hope those of you that were watching the prosecution's opening statement, he also said girls down the hill. But we all knew right away that that was a mistake. And later on, when they played the video, it did say guys down the hill. Police have to admit that the guy on the video, you don't see his mouth moving. You're not going to be able to be sure that he's the guy that's uttering those words. You're not going to be able to know whether there are more than one person at the end of that bridge. So So what will you see on the video? And again, let me describe that end of the bridge for you that you will see in evidence. If I'm walking all the way to the end of the bridge, like the girls AW and LG, did you have a choice? And you're going to see this on the video. You can go left or you can go right. And it looks like on the video, the girls head this way. Okay? And if that's the bridge and you head this way, there's only one way down. That's down a steep incline about 30 feet down the hill. Okay? I don't think the evidence they're going to be able to show that those girls actually went down the hill or not. They may have. The evidence may show that. Or the evidence may show that they ended up going down this lesser of an incline on the other side of the bridge. And the bridge is about that wide. There's a lesser graded slope that takes you down. Both, though, the more steep side and the less steep side take you down and funnel you down to an access road about 30 feet away. An access road, some might call it a driveway. What you're going to hear is about a guy named Brad Weber. This is his property, and this is Brad Weber's way to get to his property. He has two ways. There's that way and another way. To get to Brad Weber's house from the access road, the one way would be let me go back over here to where the bridge is, on the right side where the girls were. And you go down that hill, and then that access road goes under the bridge, and it goes that way up to Brad Weber's house. So you can imagine that under the bridge, the state of Indiana will not be able to disprove that there was a vehicle down there or that there were other people down there. And we happen to believe that the evidence will suggest that those girls may have gotten into a vehicle at that point in time. There's not going to be strong evidence about what happened at that point in time. I'm just telling you that. You can take from the information, though, from the hard data on LG's phone and some other information and data that you may see from other sources. Here's what we do know. LG's phone was connecting to the tower and receiving text messages. Where are you? What's going on? Voicemails, telephone calls, connecting to the tower all the way up until 5:44 p.m. It's going to be an important time frame for you all. 5:44 p.m. At 5:44 p.m., that phone no longer connected to the tower. From 5:44 p.m., no connection to the tower all the way until 4:33 a.m. when it reconnects to the tower, where the phone came back into an area where it connected the tower again. So for about 12 hours, close to 10 hours, that phone did not connect to the tower. This is the phone, by the way, that was, by their theory, under AW's body that entire time. You will also find out that after 4 o'clock, when they say Richard Allen never came back to the scene, he left and never came back. Their theory. He didn't take the phone with him. That's what they're going to tell you. After 4 o'clock, human hands handled that phone. Richard Allen was at home. He never came back. That's the evidence. You will also hear something about what are called exigent circumstance pings. You may have seen these on television. That is, on movies and things like that. where somebody is lost and they called AT&T in this case and said, hey, will you try to see if that phone's in the area? And that happens here. And consistent with what we know from the phone itself, the last time that the phone connected, according to the exigent circumstance ping, the last time LG's phone connected with the tower on the 13th, Monday the 13th, was what time? 5:44 p.m. That will be something that you will hear. Every 15 minutes, that phone was being pinged. And every 15 minutes, it was showing it's not connecting with the tower. The last time she did, 5:44. So at 7 o'clock p.m., 7:15 p.m., 7:30 p.m., these aren't exact times. They're at different times, but it was roughly in 15-minute increments. That phone is not connected with the tower. Around 10 o'clock, you will find out that Steve Mullen, he's a law enforcement officer that will be a witness in this case, that he contacted law enforcement, contacted a guy named Mitch Blocker with the state police. Mitch Blocker was the guy who knows about phone ping and how to analyze them. And Steve Mullen wrote up a report about what Mitch Blocker concluded. And he concluded either the phone has not been connecting with the tower since about 5:44 p.m., so either the phone is no longer in working condition or it's out of the area. Well, we know, and you're going to find out, that the phone was in working order when it was found. It was in working order. So take that one down. It's left with the phone without of the area. The phone that was supposed to be under AW's body. So again, you will learn then, midnight, 12:15, 1 a.m., the phone is not connected to the tower. And that at 4:33 a.m., and we're not going to be able to tell you, and I don't think the evidence will, nobody will ever know what exactly when that phone, where it was when it reconnected or did connect with the tower. Of course, the defense is saying that the phone was out and that it came back in. What we will tell you is that at some point in time, after that phone came back into the area, somebody brought those girls back down to where they were ultimately were found. And that was probably after 4:33 a.m. And you're going to find out at 4:33 a.m., when you're in a building and you try to text somebody and there's too many walls and you walk outside and you start getting texts and the texts start. At 4:33 a.m., 15 text messages and then other text messages populated into or onto that phone once it connected with the tower. You're going to find that out. And at some point in time, and I don't think the evidence will be able to, at some point time after that, after the thing with the phone, somebody killed those girls and somebody put the phone under the body, where it was then found around noon, a few hours later. We are obviously telling you that the evidence will be that those girls were not where they were found on the 14th. They were not there on the 13th. And this will be a big help. But is there other evidence out there that would also suggest that the girls were not there on the 13th? Yes. So you're going to find out that there was a search party assembled very quickly. It wasn't in LG's nature, I think, that Becky Patty will tell you this. It wasn't in LG's nature to be late like she was. And so the family, very close family, they got together right away and said, this isn't right. We got to do something. So you're going to find out that they sprung into action very quickly, and they got a search party together. And it grew and grew. Facebook and stuff like that. They got on Facebook and said, "Hey, these girls are missing," and you're going to hear from former fire chief Starrett, and he's going to tell you about his part of the search party. There was 4 or 5, maybe six guys, and here's where they searched for those girls on the 13th when those bodies, according to their theory, should be over there. If this is I think this end of the bridge where it happened, if this is where the bodies were, where the girls were abducted, and you can go down that hill, Starrett and his people that were with him, they searched on this side. The bodies, by the way, were over there. This is where they were, indicates Starrett and his people searched over here some. And then they came over here and they searched over here for 4 hours in this area. And the girls were across the creek. And one thing you guys are going to find out is it's not very far from the end of the bridge where the girls' bodies were found across the creek. It's kind of like that way from the edge. So if they went down the hill, here's the bodies. They were found that way, probably less than 300 yards. It's about 800 and some odd feet, not very far. And that's at an angle. And what Starrett will tell you is my people that I was with, and they were spread out, and they were looking on this side. Well, they weren't on the side that the bodies were. But what did they see on the side where the bodies were? People with flashlights on that side. And not one person saw any bodies over there because the defense theory is the bodies weren't there. They were somewhere else. And you're going to find out a little bit about that area, or not a lot, a little, probably a lot more than you want to maybe. That the area where the girls were found, it's flat. It's a natural place for those people to be walking, and the flashlights. Now, Starrett, I don't want to oversell. Starrett's not going to be able to tell you that they were there. The flashlights were where the bodies were for sure, because he doesn't know, but he just saw flashlights over there. You're also going to find out that, and Mr. McClelland talked about it a moment ago, there's clothing in the creek, okay? And that's going to be important. One thing you're going to find out is this. The people that were searching, they were preparing for the worst, that maybe those girls were in the creek. Maybe they were floating or on top of the water. So many of the people were going along the creek bed looking for the girls. Now, if the state's theory were true, that clothing of the girls that were found on the 14th should be in the creek where the people are searching with their flashlights, and nobody saw any clothing on the 13th in the creek. It was only until later that they saw the clothing in the creek. As an additional piece of evidence that you will have to show that the girls weren't there on the 13th, is there anything else? Yes. Jerry Holman will tell you that from where the girls were found to the bridge, you can hear voices. And around the time that their theory is that Richard Allen abducted these girls, there would be people walking on the bridge. 4 people. You'll hear from them. Daniel Pearson, Shelby Hicks, Cheyenne Mill, and Shelby Duncan. 2 of them went to this end of the bridge where it's really, again, the bodies are over that way. 2 of them were at the end of the bridge, and you're very close, I think, that I would call it close to where the bodies were. Again, none of them heard anything. No screams, no voices, No wrestling, nothing. Right around the time when they say Richard Allen was abducting those girls. I mean, if anybody killed those girls, the evidence would show on the 13th, just for that reason alone. There was no sound of anything. The evidence will be those girls were gone. There might be other evidence out there that you guys see individually, but this is the type of case where a jury sees and picks up on things that we don't see. That always happens, especially on longer cases. You guys might pick up. So keep your eyes open and your ears because you're going to see some things as well. Well, I know I've been going on long and I could go on with this longer. But this is important stuff and I'm going to try to sit down as quickly as I can. But I do want to talk about what I think the state thinks and what they say under oath about bullets. And we'll call it confessions and the timeline. I want to go through those very briefly. Confessions. You have this and the other evidence I've talked about, and none of that stuff matters. So they can put up, and I expect they're going to put up person after person after person, and video after video after video, and audio after audio after audio of all these confessions of an innocent man. But the hard evidence, it doesn't matter that the hard evidence shows otherwise. And what you're going to find out, you're going to see these videos, and we're going to show you videos of Richard Allen in his cell and how this guy was taken out of his house, as I said in the mini opening, away from his wife of 30 plus years to a prison where he's standing in this tiny little cell with a bed about that high on the ground, about 2 feet from a toilet, watched 24 hours a day, told he's a baby killer. He went in there fragile to begin with. You're going to see some video that is upsetting, and it should be upsetting. Even the video of him talking to his stepdad, saying, "Don't give me any money. Don't hire me a lawyer." You're going to find out, even in November, within 2 weeks of him being at Westville, he said, "Maybe I'll just admit to all of it so that you guys don't have to suffer. You won't have to suffer." That was at the beginning when these confessions happened. It was after close to 6 months, 5 to 6 months later, after he had endured what he had endured, confessing to shooting those girls in the back when they weren't shot. The things I told you in that mini opening, you take those confessions for what you think they are worth when you compare it to the other evidence. That's what we will ask you to do. What about these bullets? Well, you're gonna hear from some psychologists, Dr. Gracian and Dr. Westcott, that are our experts, and they're going to tell you that the ingredients were there for false confessions. What Richard Allen endured. What about the bullets? The magic bullet, the one witness called it. Here's what you're going to find out. First of all, unless I see something I haven't seen before, and maybe even just missed if it existed as just a kind of, maybe these photos exist. I haven't seen them. We'll see. There's the magic bullet that is in the ground, they say, right here. And you see some photos of that bullet as it's in the ground. And maybe they will produce these, but I haven't seen them. There's not a video of this important. This is one of their main pieces of evidence. There's no video or photographs of that bullet being taken out of the ground and photographed from the angle, and that angle, and that angle, and that angle. Just a photo of the bullet in the ground, and them later on, a different, a bullet a different photograph of a bullet at the lab where it was tested. But in between, I didn't see anything else. So, what else? Well, you're going to find out about this bullet that law enforcement commonly uses 40 caliber bullet. Guns that use 40 caliber bullets. Even Sig Sauers are very common. And if there's gun people on the jury, they may have heard of the Sig Sauer. That's the gun they found at Richard's house, a very common gun. Law enforcement use Sig Sauer 40 caliber bullets. So you would think, okay, let's test and find out whether it's as police were walking around the area, did they drop a bullet? Let's see if that happened. Hey, I want every police officer that was at the crime scene walking around, I want to know what kind of gun they had and if they're missing any bullets. You think that would happen, but it did not happen. I want every 40 caliber handgun that police had tested. You would think that would happen, but it did not happen. You're also going to find out that Brad Weber, remember that guy? He's the guy whose driveway goes all the way up to his house, right? He had a 40 caliber Sig Sauer in his vehicle, and that handgun was tested, and it was not excluded as the weapon. Okay? Here's what you're going to find out about the test itself. And we have an expert named Dr. Warren, and he's going to be very, very critical of the way that this weapon, this testing process, was handled. Here's the way it was handled. This is what you will find out. The bullet that they got out of the ground had markings on it that you can see. This bullet, this is important. Mr. McClelland talked about this a little bit. It was never shot. It has never been shot out of a gun. It has been cycled through a gun. Does it make sense? And it had sufficient markings. This bullet did. So what they did then in law enforcement took a pristine bullet and put it into Richard's gun, and they cycled it through to recreate what that bullet, how that bullet came when they found it. And when they took the pristine bullet after it had been cycled and they looked at it, some of the markings were insufficient. They just couldn't be seen well enough. And they're trying to compare that to this bullet and did have sufficient markings. That's the starting point of the problem with the bullet. So what did they have to do? They had to then, law enforcement, they really wanted this to work out. So they fired the bullet. So there's more pressure on it, and the tools and the things inside can show more markings. So now they're comparing a bullet that was fired out of the weapon. Now it has sufficient markings on there too. At least see it. They're comparing that bullet to the bullet that was found in the ground that had insufficient markings or that had sufficient markings. Now this bullet has sufficient markings, and now they're going to tell you, oh yes, they're the same bullet. It's comparing apples and oranges. That's what you're going to hear. By the way, and look at you all have eyeballs. When you see these comparison photographs, and your own eyeballs will tell you that these don't match. Your own eyeballs. You don't need an expert, folks, because you have eyes. You'll also hear things. I don't want to get too muddied down. You're going to also hear about subclass. Any gun, let's say a Sig Sauer, that fires a weapon, it's going to have similar two markings. That's what they call it on each individual bullet. But they're also going to be similar subclasses. And there's some of that going on here too. And these bullets are consistent in some ways because they came from, gun that was similar. And these subclasses, Mr. Rossi will be handling all of the ballistics, and he will be telling you why that is important and why all of the ballistics, and he will be telling you why that is important and why it shows that this magic bullet is of really no value. You will also hear from Melissa Oberg, who is the state's witness. She no longer works. I'm sorry. I know people might have to go to the restroom, but I'm going to quickly as I can, guys. I really am. I'm sorry. Melissa Oberg, she will tell you that she's no longer with the Indiana State Police. She's the one that tested these bullets and is the one that's interpreting the evidence of these bullets. And you'll hear her say this. When I did this over 1,100, 1,300 times, and when people, I was never wrong. Now, the people that I worked with, I could check their work out, and their work, they were wrong, but I was never wrong. That's the person that's interpreting this bullet. You'll hear her testify. They've got a magic bullet, and we have got other evidence. I'm going to quickly go through the timeline, and then I'm sorry, this is so important, but we'll talk about Betsy Blair again. Betsy Blair arrives. So the third thing that they can try to say that they have is a timeline on their side, and they cannot. The evidence will not support that. The timeline, Betsy Blair gets to the trail around 1:49 p.m., right before Kelsey drops the girls off, right? So drops them off at the Mears entrance. They go on Betsy goes onto the trail. She walks the trail. She gets to where the high bridge starts, where you see all the evidence. This will start to make sense to you. It's hard to conceptualize it right now, but the trail ends, and there the bridge begins. And when she got to where the bridge begins, she saw with her own eyes, from about 50 feet away, a guy who they're claiming is Bridge Guy. What they failed to tell you, the state, just a moment ago, is that the person that Betsy Blair observed was in his early 20s, maybe 30s. He had brown, fluffy hair. Richard Allen has kept his hair short since 1989. His wife will tell you about it. He was in the military. He likes it short. And he obviously ain't 20 years old. Betsy, Richard, Rick is short. Betsy Blair did not say the guy was short. That's the guy that they say is the killer. Betsy Blair, inaudible. I told you about the car that Betsy Blair saw. Doesn't fit the description of Richard Allen's car. Totally different. That timeline will be a problem. Sarah Carbaugh. See, one way to kind of easily understand that, who these witnesses are, and I know it's hard right now, but Betsy Blair is at the beginning. I'm seeing them look like bookends. Betsy Blair is at the beginning. The person that she saw, that they say is Richard Allen, the 20-some-year-old guy with brown poofy hair, that's at the beginning. Sarah Carbaugh's at the very end. They're bookends. They're supposed to be the same guy, according to their theory. So this Sarah Carbaugh, who did she see? Well, she's going to testify. I think you're going to like her, but her story just is completely inconsistent. That's what you'll see. In 2017, in June of 2017, she was interviewed, and she said that the guy she saw, and that they failed to tell you this, the guy she saw had a tan jacket on and was muddy Okay. 2019, 2 years later, after the video's been out, photos have been out, her story is now 2 years later, no. Well, they didn't say no. She just said the guy I saw had a blue jacket on and was bloody. Now he was muddy and bloody, like a pig had. He had slaughtered a pig. Her story's completely changed. And you'll have to take her testimony for what you think it's worth. But if Betsy Blair did not see Richard Allen, then their theory is falling apart. And you can conclude that there's reasonable doubt that she saw Richard Allen, and you'll know what to do. If Sarah Carbaugh did not see Richard Allen, or you don't trust your testimony, then you will be reasonable doubt. And if they didn't see the same person, the person they described are two different people, they're saying it's the same person, Richard Allen. Their timeline will not work. In the home stretch here, other stuff that's important. This is what I've labeled it. DNA. Richard Allen. No DNA at the scene. Not connected in any way. Social media on Richard Allen. No connection to the girls. No connection to the scene. No connection to any of that business. Forensic data. None of that connecting Richard Allen to anything. Talked about the hair on AW's hand. In just 7 years. Really? I mean, that's what you're going to find out? It's taken them 7 years to figure out whose hair is on her hand, whether it's family or not. They're scrambling right now. Here's another thing you're going to find out. Dr. Kaur is the guy who conducted the forensic pathology. He's the forensic pathologist who conducted these autopsies. He's going to tell you that it looks like there were 2 blades used on the girls' necks, a serrated blade. Isn't there a lot of stuff here? A serrated blade and a non-serrated blade. And they're going to tell you that Richard Allen claimed that he killed those girls with a box cutter at some point. Serrated blade and non-serrated blade. That could indicate 2 people is what the defense will tell you. 2 different people using 2 different knives. There's evidence of that, and that's what that evidence is. 2 people or more. I'm not even talking about the crime scene. I'm not going to do that to you. I think we all need to take a break. But when you see the crime scene, you're going to understand that it's highly unlikely that one person could have done everything that was done to those girls and surrounding and around those girls. It's a very bizarre scene. There's sticks laid across these girls. The court. Mr. Baldwin, with all due respect, you are very closely and are arguing the evidence. This is not argument. This is opening statement. Sir, I've given you lots of leeway. Move on, please. Mr. Baldwin, thank you. There were sticks on those girls. It is a scene that you will see, and you will have to make a decision about, can one person do that? Well, you're going to find out from the evidence that they didn't think that one person could do all of that until Richard Allen was arrested. Who's they? Tobe Lazenby, the sheriff then. He thought not one. It's going to take more than one person to do all that. Who else? Tony Liggett? You need more than one person? And there might be other people, other law enforcement, that get up and testify that it was more than one person, that it would take more than one person. Please wait. Richard Allen is innocent. He's really innocent. And that is the end of the defense's opening statement. All right. I need to see what everybody's been saying because Good God. Robin S. says, I always trusted what you reported from the trial. Well, thank you very much. Mustang says, I did also. Why are they leaving nasty comments? Just because they're nasty people. They don't want the truth. They are too busy manipulating it and making stuff up. You're just reading a transcript. Right. I agree. I'm not going to put that on the screen, but the Bish formerly known as Delulu, yes, they are that pathetic. It wasn't just Marv, all the reports were the same. Yeah, except for those from Mata and Griftard. Okay. Let's see. They should be glad these transcripts should pay those bills and get them the attention they so desperately crave for at least another 6 months. RA originally said he was there at same time, changed his time at later date. Yep. Wasn't RA's car seen driving to the car park after 1:30, not leaving? Yes. And you will see that in the later testimony. I'm glad you guys are picking up on this stuff. I only know what type of car I own, not a car person. I'm not either, so don't feel bad. Most people don't care, or most people don't take close notice of whom they pass or what cars they see. I have a designated parking space, and I could not tell you the make of the two cars, on either side, and I've seen them. I agree 100%. Every day for years. Yeah. Oh my goodness. Robin says BG is not BW. BW is in his van driving home. Right. Water damage does this to iPhones. Yes, it does. You doubt that they were brought back from anywhere? I agree. Yeah, the fire chief, according to the defense, the fire chief was gonna say that he saw flashlights in that area. Good luck on that. He's stating his whole case. Yeah, it sure seemed like it. They were on the other side of the creek. Can he prove it? Apparently he didn't. Very important stuff. He is suggesting magic bullet may be planted in the ground between the girls and in the trinket box, but why not plan it for other suspects? Good question. I saw the photos from the evidence. The marks looked fairly similar to me. The witness identified BG from the photo video. Oh, but that's right. RA claimed he wasn't there at that time at a later date. Yep. Or two different tools. At last, a reminder to Mr. Baldwin. I'm surprised Gull didn't say that before. I was too. But she kind of let him go, and I'm glad she did. Wow, at last we got to hear the opening statement. Thank you, Marv. Thank you, Marv. You're the best. Marv, I typed those questions and wondering as you read the transcript. I'm glad you are doing that because it makes us all stop and think. So tomorrow, tomorrow I'm going to sleep in because I haven't been sleeping good. So I'm going to try to sleep in. We're going to try to get through I think Becky Patty's first. Yes. We're definitely going to try to get through Becky Patty. Anna Williams, and I think the third person to testify was Kelsey. Tomorrow. But that'll be late afternoon, evening. Nobody said that we wanted Richard Allen to die. Nobody here has said that. So I'm not sure where you're getting that from. I didn't say I wanted him to. So don't come in here and try to put words in my mouth. Hi, Brandon. How are you? All right, everybody. I will make sure that I do a community post telling you what time I'm going live tomorrow. And that way you'll know for sure. And I'll also put it in the Facebook group and try to put it in Discord also. So that way you guys will know ahead of time. I just got to see how the day goes, and then I'll create the thumbnail and get it up there. Thank you for being here with me today. I really appreciate it. If you have any questions, put them underneath the video. I'll try to answer them. Any comments also. And thank you once again. And I'll see you tomorrow. Have a good night, everybody.